The history of marriage before the Supreme Court, you'd have to go back to 1885, I think was one of the first Supreme Court cases that really addressed marriage. It was in the polygamy context, and the Supreme Court there said that marriage is a lifelong union of one man and one woman. You'd have to fast forward almost 100 years to 1972. In the case of Baker versus Nelson, was the first time the Supreme Court addressed an issue related to the definition of marriage, similar to the challenges to marriage that we see today. In that case, two gentlemen applied for a marriage license in Minnesota, and they were denied because Minnesota defined marriage as between a man and a woman. So they sued the state of Minnesota, claiming that Minnesota was violating their constitutional rights. The Supreme Court of Minnesota upheld the state's laws, saying that the state has an interest in promoting marriage between a man and a woman because that's their ideal relationship to provide children with their ideal home and upbringing. That was appealed to the Supreme Court, and the Supreme Court dismissed the appeal in one line, saying that the constitutional claims raised there did not present a substantial federal question. So that was in 1972. There's a lot of lower court cases, a lot of state Supreme Courts addressed this issue, but this United States Supreme Court didn't address anything related to this up until 2 years ago in 2013. I'm sure most of you are familiar with two high-profile cases that were heard in 2013. One, a challenge to the Proposition 8 amendment in California, and the other, the United States versus Windsor case, which was a challenge to the federal government's definition of marriage. Those two, very briefly, the Supreme Court didn't address any merits in the challenge to Proposition 8, which was California's law passed by the people of California that defined marriages between a man and a woman. In that case, the state of California chose not to defend their laws, so the Supreme Court dismissed the appeal and said because the state wasn't defending it, no one else could defend it, and they wouldn't hear the case at all. So the Supreme Court didn't address states' marriage laws at all in that case. In the Windsor case, which was the challenge to the federal definition of marriage, where the federal law said for purposes of the United States government, marriage is between a man and a woman. The Supreme Court addressed that in Windsor and struck that down, saying that the definition of marriage has been, quote, a traditionally state-defined institution. The Supreme Court there said, even though under states' definitions, marriage between a man and a woman has no doubt been thought of by most people as essential to the very definition of that term and to its role and function throughout the history of civilization. In Windsor, the court said the federal government was trying to step into the state's role and would recognize some states' definitions of marriage and not others. And the court said that wasn't the role of the federal government. The federal government didn't have an interest in domestic relations, and that was up to the states. So that's the last word we've had from the Supreme Court on marriage.